again, if you've never looked at the Iroquois Constitution, all these documents that we're going to go through tonight, we suggest that you take time to read them in your own. As Dr. Carter G. Woodson always says, there's two types of education, one that you're given and one that you give yourself. Judge Joe Brown, we definitely going to need your help on this because this is in your backyard. We want you to educate the listeners that are watching this. We're just going to hit some points on this Constitution as we get ready to get into the bill. If you can go to Article 1, Section 8, Chief Biko, where it's going to describe the powers of Congress. And the one we want to focus on is Congress declares war. Can you elaborate on that a little bit, Judge Joe Brown? For the people who have never looked at the Constitution, don't understand the theory of operation of this system. The way I like to look at it is the Constitution is like the operating manual of this system. If you read this Constitution, you get an idea how the internal mechanisms are supposed to work. You want to share with the listeners?
The actual Constitution of the United States takes about 15 to 20 minutes for an adult who has been through high school to read. It's a lot simpler than reading the rule book that you have to be familiar with if you're going to get a driver's license and pass the written part of the test. It's not long. Article 1, Section 8 does a lot of things. One of the things in there that is most important to the immediately prior discussion is part of it that says the obligation of the commander-in-chief, which is the president, and also of the armed forces, is to, quote, enforce the law of nations, unquote. You have to tie that in with Article 6, which deals with the supreme law of the land, which consists of three things. One of them consists of those treaties that have been ratified by the U.S. Senate. There were a number of treaties that involved, amongst other people, the parties to the Iroquois Confederacy. And it says in Article 6 that those elements of the treaty that we in the United States had with we, or some of the we, who were embraced by the Iroquois Constitution, that is supposed to be enforced by all judges in the land, state or federal. So those treaties were ratified with what were perceived to be nations. The Iroquois nation was perceived to be just that, a nation. And that's one reason a lot of Black folk don't understand what goes on between the descendants of those Indian nations and what become known as African Americans, Afro Americans, Black, Negroes, colored, or whatever you want to say, is they don't have treaties because they never had the status of being perceived as a nation.
Now, I love the bill. You're getting a little ahead because we get into the treaty part, but just for clarification, when when the United States government through its Congress declares war, is that a written document when they declare war?
That's the power to declare war. That rests with Congress. There are also inherent policies that are supposed to lie with the government and the chief executive, which is to engage in acts of war that are not officially declared. We didn't exactly have a declared war for most of what's been going on in the Middle East over the last 20 some years, because how are you going to declare war on an idea? But how do we get into the Middle East? And what is also said in Article 1, Section 8, which few people understand. There's a part in there that says it is the responsibility of the United States Navy to pursue, eradicate, and defend against piracy wherever found in the world. Now, you have several treaties that become part of the supreme law of the land that declare hijacking airplanes to be acts of piracy. So it devolves upon the U.S. Navy to resist and suppress piracy wherever found in the world. When Al-Qaeda secures 5 aircraft that are hijacked on 911 and engages in an act of piracy, multiple acts of piracy, it then becomes the duty of the armed services to pursue and carry out a perpetual state of war that is set forth by Article 1, Section 8. It says, wherever found, it is the obligation of the American Armed Services, specifically the Navy, to pursue, eradicate, and suppress piracy wherever found in the world. So that obviates the need to declare war and says there's a perpetual war against piracy. But of course, you got the jackass George W. Bush saying the war on terror, which is a war on a condition, which is an oxymoron. How you going to fight a state of mind? Officially, who do you declare war on? But he never said it was piracy. But Article 1, Section 8 is inherent in this war power with the perpetual state of adversity against piracy. That's why the United States Navy and the navies of a lot of other places in the world are over on East Africa's coast dealing with piracy. It is also part of this thing of enforcing the law of nations, which is part of Article 1, Section 8, which establishes a perpetual state of animosity or war against those who deviate from the law of nations. That said, that's actually why we have a legal justification for being involved in the Middle East, is because what happened to set this off on 9/11 was essentially an act of piracy. You listen to the Marine Corps hymn, and it says, from the halls of Montezuma to the shores of Tripoli. When the U.S. Marine Corps was involved in the very first decade of the 19th century with an affair in Tripoli, that was because they were dealing with the piracy of the Barbary pirates. So that is part of the legacy of the American Armed Services, which is to pursue, eradicate, and suppress piracy wherever found in the world. It's an interesting thing. But by the way, I didn't learn that in law school. I learned it in the 5th and 6th grade in LA, California.
Great explanation. Chief Biko, can you share the document? I'll give you the heads up when it's time to stop sharing it. Let's get to the next point, which Judge Joe Brown already jumped ahead. And for those that are viewing, you can tell that Judge Joe Brown is going to give you a detailed description on these articles. So just follow us and listen and learn. Let's go to Article 2, Section 2 of the United States government's Constitution. And thank you again, Judge, for that detailed explanation, how that piracy can be an out clause from Congress, quote unquote, declaring war. Article 2, Section 2, we're right here where it describes treaty procedure. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25. Okay, let's get down to it.
You are at Article 1, Section 1 of Article 2.
Right, we need Article 2, Section 2, Chief Biko.
That's dealing with the president shall be commander-in-chief of the armed services. Correct. Of the Army and Navy of the United States and the militia of the several states when called into the actual service of the United States.
Not that part, Judge, if you don't mind.
That's Article 2, Section 2. What are you trying to get to?
Second paragraph, he shall have power.
He shall have power by and with the advice and consent of the Senate to make treaties, provide 2/3 of the senators present concur, and he shall nominate by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, or in the courts of law, or in the heads of departments. Okay. He is chief diplomat of the United States of America.
If we can go right back to that first sentence up into Senate, where it says he shall have the power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate. So explain to the people basically the president has to get 2/3 of the Senate in order to have a valid treaty. Is that correct?
Yeah, that's why it's part of Article 6. It becomes part of the supreme law of the land along with the Constitution and such laws as may be passed to carry out the Constitution, not just administrative stuff, but things necessary to make sure the Constitution works. Those are the three categories. The Constitution itself, which includes the amendments. Mm-hmm. That's one. Two, such special laws is necessary to effectuate or carry out or administer the Constitution. And three, such treaties as have been ratified by the Senate, which requires 2/3 vote of the Senate to ratify. So he is the chief diplomat and he may negotiate treaties. There's one in particular that applies to today, I'll come back to later. Okay. That was negotiated by President Bill Clinton in 1999 and was ratified by 2/3 of the U.S. Senate, and it is part of the Supreme Court, the law of the United States. It's interesting in its impact on world and national affairs right now, and it has a great deal to do with our foreign policy at this point, but most people don't think about it, and I have yet to see the news media talk about it, but we'll come back to that.
Thank you for giving a detailed explanation. And the reason why we're touching the way we're touching is because a lot of people don't understand how this thing works. So when you're explaining how treaties come about, this is for the listeners. So as we go down this story, they're gonna be able to see some things. So let's go to Article 6, Chief Biko.
Well, let me add one other thing with this one too. This one we are talking about right here is why, in the case of United States Department of the Navy versus Egan, decided by the United States Supreme Court in 1988, they declare that as the president is the chief diplomat of the United States, he has absolute and unquestioned authority to classify or declassify any document he chooses. Also, we just discussed that he is commander-in-chief of the military. Also, for that same reason, he has absolute authority to classify or declassify any document in any form, shape, or fashion he chooses. He can classify or declassify in full or in part. It's been decided. And you might wonder why somebody is bringing a charge against or charges against a past president for exercising that constitutional authority.
Not understanding the operating procedure of how things work.
Well, perhaps understanding the operational procedure, but not giving a damn, just bringing the action as an administrative thing, knowing it won't stand up, but using it for what they call lawfare to impose problems that somebody has to deal with. And by the time the problems get resolved, it'll be a moot issue because what they're putting them out there for will be too late to do anything about.
Gotcha. Article 6, Chief Biko. If you don't mind, we're going to get down to what Judge Joe Brown already touched on, which is the supreme law of the land, which is the treaty. Article 2, Section 6. Are you under Article 2? Yes.
Article 6.
Okay. Yep.
Okay. Article 6.
So this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the constitutional laws of any state to the contrary, notwithstanding. I want to role play with you real quick, Judge Joe Brown, as you elaborate. Let's say I'm a Cherokee chief, and you are a military general coming from Britain to establish a colony. If we go into treaty together and your colony later becomes a state within the United States government, our agreement is binding because it's supreme law of the land, even though the United States government is created after our treaty. Am I interpreting that right, or can you clarify?
What happens is this: the colony involved, when it becomes free of the monarchy in England, the sovereign power in England being the monarchy, When it becomes free of that, it is for a short few years a state, a nation state, a nation. It is a small, weak nation that it eventually will join up with 12 other weak nations to form the United States of America, which can be translated with synonyms into the United Nations of America. And they bring in their own rules and their own treaties, which are incorporated into the system of the collective agreement, which is the entity now known as the United States of America or the United Nations of America. So we have a situation just exactly like what we have with the Euro Union, where you have these entities that have been at war for thousands of years, France against Germany, Prussia, Saxony, Greece, Turkey, England, no longer part of the Euro Union, Switzerland, Spain, Portugal, all these countries fought each other tooth and nail, and they're sovereign entities, but they unify into a collective now, which to an extent is modeled on the Iroquois Confederacy. And to an extent, the U.S. Constitution has its elements from the Iroquois Confederacy. And what is adopted as law by this early nation, this colony, once it becomes free, are to an extent incorporated into the United States. There is a question about the effect of ratified or operative treaties or agreements between states that were pre-existing to the point when they became states of a union rather than colonies. The general propensity is they match up because essentially there were a lot more Native Americans, Amerins, Indians than there were white colonists. And people died. Correct. So this was serious business. It wasn't just academic.
Just to untie the knot, just for the viewers. So whatever our agreement was when you were at the colony state and I'm chief of Cherokee territory, that treaty would be binding when that parent company absorbs all those colonies and makes the United States government.
There were some actions by the U.S. Senate pursuant to this Article 6 situation that in essence incorporated a great deal of the same elements that the individual states had entered into when they were colonies with some of the Indian nations.
Okay. Good explanation. Hopefully, if you're following along and you're listening to this dialogue, we're just talking theory of operation right now of how the Confederacy operated versus how the United States government operates. If you can go to Article 1, Section 2, Chief Biko. And if you can put in your words, Judge Joe Brown, what does Indians not tax mean to you? Article 1, Section 2.
Okay.
Are you at the right article, Chief Biko?
Yeah. See, you have to take this in context. If you're born in basically the continental United States or one of its territories or protectorates, you are a citizen. If you claim precedence.
Not cutting you off, Judge Brown. What is continental? Are you talking the entire North
America?
Got you.
Now Alaska. Gotcha. Now Hawaii. Now Puerto Rico. Now the American Virgin Islands. Now American Samoa. Okay. You are on American territory and you're an automatic citizen. But if you don't pay taxes because you claim precedence and elect to be a citizen of a sovereign Indian nation, that's what they're talking about.
Okay. So keeping it simple for the people who are listening, if you are a citizen of, let's say, the Cherokee Nation, then this applies to you.
Yes, you
Gotcha.
don't have to pay American taxes if you exercise that citizenship.
Okay. Gotcha.
And it was modified to an extent some 70, 80 years, 90 years later when it started talking about reservations or recognized Indian territories.
Thank you for that break.
By the way, these rules sound complex, but actually, the rule book is only about an eighth as long as the rule book is for the NFL. The computations are actually more simple than what you get when you see the referee, the umpire, and the line judges huddling together, deciding what to do when a flag's been thrown on a play.
That's why we're doing this tonight, Judge, which you just explained. We want to let the viewers know that it's not hard to understand the government you're operating under so that we can ultimately start looking at some things that we might want to do differently moving forward. Thank you for sharing that. If you know your favorite football team or baseball team or basketball team, if you know all the rules when he travels, when he double dribbles, why can't you learn the government you operate up under? Great point, Judge Joe Brown.
And it takes less time to read the Constitution than it does the rule book.
If you can cite to Article 1, Section 8, Chief Biko, and that's going to describe commercial relationships through Congress with Indian tribes. You want to build on that, Judge Joe Brown, for the viewer?
Well, you're dealing with interstate, not interstate commerce, but you're dealing with international commerce in a way. It's a weird kind of thing. When you read the Constitution, you have to understand this was 235 years ago, 1789, when the Constitution, this instrument, was ratified. So 235 years ago, you had a wilderness. You had 13 colonies in a heavily forested jungle, heavily forested jungle. And you had a scant white population, and you had 2,000 miles from where they were to the west coast and the Pacific Ocean. You had a desert that extended all the way up to the Mississippi River almost. And you had very hostile environments. So you're in this primitive forest. The fastest you can go is probably if you're on horseback. They started building canals, which sped things up. You had some riverine traffic, but communications were slow, conditions were isolated, and somebody might decide that they're angry at you, they'd like to smile by nailing your scalp to the lodgepole.
Thank you for that build. And lastly, Chief Biko, I want you to do a search for the word American on the U.S. Constitution. You're on mute, by the way, Chief Biko.
Shows nothing.
All right. Type in citizen. Let's do a search for citizen on the United States government Constitution.
Shows up 11 times.
Okay. Put in slave.
0.
Put in slavery.
Nothing as well.
Negro.
Nothing as well.
Black.
Nothing.
Colored.
Nothing.
And lastly, African American.
And nothing.
Okay. If you can go ahead and pull up the Treaty of Moultrie Creek, now that we have an understanding of the theory of operation of the United States government through its Constitution, let's do a real live acid test real quick with a treaty, and let's see what we can see or what we can learn from this example. If you go down to that last paragraph in the treaty, Judge Joe Brown, how would you interpret when a treaty says that it's done in the independence of the United States, nobody from Senate, signed this document, so it wasn't voted on. The 2/3 didn't vote on it. President didn't sign it. You only have military officers signing that treaty. Is it safe to say that this is an unlawful and invalid treaty?
No, it's not necessarily invalid as an instrument, but it's not a treaty. See, what goes on is you have a situation where, as a matter of tradition, when you had active combat, active hostilities going on, that became a military district. And the military commander of that district was entitled to issue dictates and orders relative to military operations and administrative matters. As commander in chief, what usually happens is the president has the opportunity to issue a superseding order. But if one of his commanders orders something, he's not going to necessarily countermand it or even do anything with it. It's kind of sort of, you're in the Army or you're in the Marine Corps, and there is the general, the colonel, the major, the captain, the first lieutenant, second lieutenant, and you're in a platoon, and your platoon sergeant gives you an order. We aren't necessarily going to expect the captain of the company to go back and get involved. There is a standing order. He can countermand it, but you have a subordinate military official, the general. He issues an order. It stands unless his superior, meaning a higher ranking general, or the commander in chief, the president of the United States, issues a countermanding order.
So just for clarification, I'm going to act like I'm in the 3rd grade and I'm going to play dumb just so I can get clarification whether the listeners understand or not. So what you're saying is they can write the word treaty, like this says the Treaty of Moultrie Creek. It is not adhering to jurisprudence of the Constitution where the Senate gets the 2/3 vote and the president gets consent from the Senate. This is strictly a military operation. Are you saying that because there's active battle going on, the military can supersede the
It's not a treaty.
But they're calling it a treaty. Okay, so they'll call
in other words, just because something says it's something doesn't mean it's something.
Okay.
In other words, hey, remember what I said about he's got a Prius and it's black and there's a Rolls Royce over there that's black? He can't just say, I got this Rolls Royce over here. Hell, he still have a Prius. Now, I'll give you an example. Reparations. There was a reparative act that was a military command order issued January 16th, 1865 by General William Tecumseh Sherman. It declared that all colored families could apply and receive 1 army mule and 40 acres of confiscated rebel land.
Mm-hmm.
Sherman's order became operative in the military district he had been assigned authority to. We just talked about the authority of Congress, the authority of the president to appoint subsidiary officers and officials.
Mm-hmm.
Without going through the process. He appoints General Sherman to be in charge of this military district. Sherman actually was confirmed in that position by the U.S. Congress, which has 2 houses under Article 1. One is the House of Representatives, and the other one is the Senate, 2 chambers. Mm-hmm. And it just happens that to back this up, Sherman's superior, General Ulysses S. Grant, approves it, and Grant's superior, since he has none in the military sense, other than the president, who happens to be Abraham Lincoln, he endorses it. And then the Republican House and the Republican Senate back it up with money. So it's 40 acres and 1 damn mule to every colored family. Okay?
That's a fancy
Now,
way, Judge Joe Brown. That's a
now,
that's a fancy way of not adhering to their own rules and regulations. But I'm with you. Go ahead.
no. So it is adhering to the rules and regulations because it's administrative. What winds up happening is after Lincoln is assassinated and President Johnson, the first Johnson we had as a president, it was a Democrat from Tennessee. He didn't like it. He didn't want his buddies losing their land, the confiscated rebel land. So since this was still a military district where this applied, the 11 former states that were a part of the rebel Confederacy, which is the use of the same word, but for representing a different governmental entity, this was a war zone still. They had not become part of the Union again. So what winds up happening is Commander-in-Chief, he issues a superseding military order that just wipes out what Sherman had ordered in his January 16th, 1865 order, which was reparations. And he wiped it out, and we haven't had that since. That was somewhere into July 1865.
Correct. Special Order 15 is what he's referring to for those that are listening. He's getting a little bit ahead, but he already answered the question. This is not a treaty. It can say treaty. However, that's why we say we're prisoners of war, because this was a military operation. And Judge Joe Brown just explained beautifully how the military in war, how they don't have to go through the jurisprudence of the government. They can stay internally within their own command within the military. Am I quoting you? Am I repeating you?
You're getting it there. Now, okay. I'm going to have